Can debt ruin a relationship? Well, sometimes yes. But sometimes the problem is not the relationship itself. It's the feeling that no matter how hard you try, you simply cannot catch up. And when the financial pressure gets bad enough, bankruptcy may have to be a part of that conversation. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. I've been helping consumers and businesses get a financial fresh start for over 30 years. Before we talk about bankruptcy, relationships, marriage, and divorce today, I want to let you know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. One of the biggest questions that I get when someone has debt and getting married is, do I have to assume the financial debt of my spouse? The answer is, in most situations, no. Credit reports are individualized. Getting married does not automatically make you responsible for debts that your future spouse had prior to your marriage, specifically if those debts are not in your name. But that doesn't mean that the debt has no impact on your life as you look at yourselves as a joint marital unit. It can still affect your household budget, your stress level, and your ability to make big financial moves together, like buying a home or rebuilding your credit as a new marital unit. So now let's talk about debt during the marriage. A lot of people assume when they come to me that if bankruptcy becomes necessary, they are going to be required to file together. Married couples may file a joint bankruptcy case, but they also have the option of filing individually while married. Even if one spouse files individually, the court still looks at the total household income because that helps determine what is really going on financially in the household. So the decision is not simply should we file, but who should file and why. Now let's turn to divorce, where timing becomes very important. Bankruptcy and divorce are separate legal processes. They can collide in ways that people do not expect. If one spouse files bankruptcy before the divorce is finished, the automatic stay can pause the parts of the divorce that deal with the property and the debt. The family court may still handle issues like child custody, child support, and alimony, but the division of assets and marital debt may have to wait for the bankruptcy court to rule on those issues. If the debt is joint and your spouse files bankruptcy, the creditor can still look to you for payment despite the fact that there's a divorce court order that may say otherwise about how payment is to be handled. There is also an important distinction between support obligations and other kind of debt. Child support and alimony are treated very differently than other kinds of debts in bankruptcy. Family courts can keep dealing with those issues, and domestic support obligations are not the kind of debt bankruptcy usually can wipe away. So the bottom line is, if you're single and considering getting married, bankruptcy could be an option to consider before you decide to tie the knot. But if you're married, you may decide that it makes sense to file individually, depending on whose debts are whose and what the household budget looks like. And if divorce is already on the table, timing matters a lot. Remember, seeking the services of a bankruptcy attorney doesn't mean you're filing bankruptcy. It simply means you're trying to understand what your rights are.